immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys engage, learn, and exchange insights on the latest developments in U.S. immigration. My name is GB Satusa, and I'll be your host for today's discussion, From Non-Immigrant to Permanent Resident, the Adjustment of Status Process. Becoming a permanent resident in the United States is a crucial step in the immigration process, but the adjustment of status process can be complex, paperwork heavy, and unforgiving if applicants misunderstand the requirements. From determining eligibility to preparing forms, gathering evidence, and responding to USCIS requests for evidence, applicants must understand each stage clearly to avoid delays or unexpected denials. To help us navigate this process, we're joined by Attorney Henry Haddad, founder of the Law Office of Henry Haddad, who brings decades of experience handling complex immigration and business matters across the United States. Attorney Haddad has represented multinational corporations, entrepreneurs, entertainers, and families in a wide range of immigration matters. His strategic insight and practical precision make him uniquely qualified to guide applicants through the AOS process. You're welcome, Attorney Haddad. Thank you so much for joining us today.
Thank you for having me on, and I'd like to hopefully talk to as many people as possible.
Now, before we begin, a quick reminder, immigrationquestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals and families can learn about immigration topics and engage with licensed attorneys who participate independently. To our viewers, it's about to get very interesting. Grab your writing pads and pens and share the link with your friends. If you have not subscribed, now is the right time to do so. Just click on the subscribe button and you're all set. Now, let's dive right into today's discussion. Attorney Haddad, can you walk us through the adjustment of status process for non-immigrants? Specifically, what are the key eligibility requirements and which types of petitions most commonly lead to permanent residency?
Well, the adjustment of status process starts with what is this relationship, family relationship that you have. So let's start with the beginning. If you are a U.S. citizen, all right, there are certain classification family members you can apply for. First ones are spouses, husband and wives, children under 21, and parents. That classification of family members are considered immediate relative, which means that there is no quota, no restrictions per country, per person, and they're given automatic processing of the application if you're a U.S. citizen. You can also apply for children over 21, married children, and brothers and sisters. For those categories or classifications, there is a numerical limitation. So what we call a quota. So for example, if you're applying for an adult child, there may be a quota of 5-6 years before the actual visa application is processed. But to get there, you have to file the application and let it sit there and wait while it goes through the USCIS and then the National Visa Center, if that's the way it's going to go. Adjustment of status is a peculiar name. It applies to those people who are eligible to change their status from a non-immigrant tourist to, for example, a resident, green card holder. And for that, it's one of two things. You must have made an admission into the U.S. You must have entered legally. You must have been here lawfully. Now, that covers a lot of people who enter on a tourist visa, enter on a student visa, business visa, all types of visas. That means you made a lawful entry. For those who entered illegally, unlawfully, there is a waiver process if you have qualified family members that allows you to be processed, not for adjustment of status, but to leave the country and go through the National Visa Center and allow you to come back in as a resident. But today we're focused on adjustment of status. And for those three classifications, children, husbands and wives, and parents, if you entered lawfully and you overstayed, you're still eligible to adjust your status. All other classifications, you will not be eligible. That's a lot of information, but that's the basic information.
All right. Many applicants experience delays or receive requests for evidence. From your experience, what are the most frequent pitfalls in adjustment filings, and how can applicants avoid them from the start?
Common pitfalls are incomplete applications. They leave a lot of empty spaces. Generally, if a question or an area doesn't apply, you have to put NA, not applicable, but you got to complete the application. That's number one. Number two, we find a lot of people don't pay the correct filing fees. They can get a rejection or request for evidence on that issue. And number three, I think the most common is supporting evidence. For example, in a husband-wife situation, they want proof of the relationship besides just a marriage certificate. For a father, parent, child, father, son relationship, they want more than just a birth certificate. So supporting is important. And we put in as much information as possible as we try to avoid these pitfalls.
All right. So looking at the current landscape, how are USCIS? All right. So looking at the current landscape, how are USCIS adjudication trends in 2025 affecting processing times, interview scheduling, and approval rates for adjustment of status applications?
Well, it's affecting in that the officers now at all levels are looking at the application in full and looking at all prior applications submitted for that person, including, or by that person, including application for tourist visas and all other information. So if a person entered on a tourist visa, but somehow they mentioned that they had kids or that they were arrested, and now on the application for residency, they mentioned kids or a prior arrest, then you have an issue that the officer has to deal with, and that puts you in a situation where, did you commit fraud? Is this intentional misrepresentation? Is this an innocent misrepresentation? You'd be surprised. We have a lot of clients who, when they're confronted with a question, for example, have you been arrested? They might think, well, have I been arrested in the US? And they put no, but in their country, they might have been arrested, and they answered incorrectly. So they have to be able to rectify that. Otherwise, it could be considered fraud, and then there are new problems, difficult problems.
Now, applicants often face life changes while their cases are pending, such as switching jobs, traveling abroad, or changes in personal or immigration status. What should they do to stay eligible and ensure their application isn't put at risk? Well,
most changes can be addressed at the time of the interview. Some changes are pivotal. For example, if the petition is for an unmarried child and the child gets married, then you're changing classification, and USCIS normally would have to be informed, or the State Department through the National Visa Center. So it depends. Change of address is important because you want to get notices from immigration. A lot of our clients, before they came to our office, they submit an application and they're waiting for immigration to process them through the system, the next step, and so on. And immigration doesn't do that. Besides sending you a receipt, it's up to you, the applicant, continue on to follow through, to ensure that when quota opens up, you're submitting the next set of documents and so on. So you got to be on top of things. Change of address is important. Most other things, change of jobs, you can address it at the time of the interview. Always address it at the time of the interview.
All right. Now, finally, how should applicants approach complex situations like possible inadmissibility, previous overstays, or violations of status when they're trying to adjust status?
Well, those issues should be addressed before filing the application. You have to find out if that particular issue, overstay or illegal entry, is going to affect the application. If it does, are there waiver applications you have to submit beforehand? Which direction is it going to go? But most important, be truthful in your application, because these things do come up. And if immigration at the time of the interview asks you a question and you're not truthful about it, that's just grounds for denial. You're in a worse situation. So address these issues beforehand. Is this issue going to make you ineligible for this application? Then maybe you shouldn't file it. Maybe there are other options. Maybe you have to go back to your home country to be interviewed, but before doing so, you have to apply for a waiver. So all these things do come up, and they have to be addressed before you file the application. I stress that over and over again because it does come up frequently.
Thank you for that. Now, to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for tuning in. Whether you are adjusting through marriage, employment, or another category, today's session is designed to help you understand the AOS process, anticipate potential challenges, and prepare effectively for it. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where immigrants, families, and professionals can ask immigration-related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We're also proud to share that ImmigrationQuestion.com is a BBB accredited business, reaffirming our commitment to transparency, accountability, and service to immigrant communities across the United States. Attorney Haddad, with your experience handling complex immigration and business matters across the United States, what are your thoughts on how a platform like ImmigrationQuestion.com is helping immigrants and attorneys connect and network more effectively?
Well, I think being able to ask questions, being able to address issues is very important. And it's also important to be straightforward, honest about whatever issues you might have, whether it's an arrest or a criminal conviction, unlawful entry. All these things should be addressed. And when meeting with an attorney or talking to an attorney, be straightforward, be upfront, because you're better off understanding your case early on rather than at the time of the interview when some surprise comes up, which we as attorneys hate surprises, but you as a client should be aware that, let me inform my attorney of everything so that they can guide me.
Thank you for that perspective, Attorney Haddad. Now, before we move into our live Q&A, let's tackle this. What practical strategies would you recommend for applicants to stay organized, track their case, and prepare for interviews to improve the likelihood of a smooth and successful adjustment of status outcome?
The first step is to gather all supporting documents, gather information about, number one, husband-wife relationship, parent-child, that relationship, gather information about support, affidavit of support. Do you have someone, your spouse or a parent, whoever the petitioner is, are they eligible? Do they meet the threshold for supporting you financially? And now under the current administration, do you have any health issues that the officer might consider to be make you ineligible because from their view, you're coming in, you're going to be a resident and start collecting government benefits and so forth. So you have to show that, your intention is to come to the U.S. or be here to work and not to be a burden on the government. But gather all these documents beforehand. Don't wait until after the application is filed and you receive an RFE, request for evidence. And then you have to run all over the place and get minimum documents to support your case. That's my advice.
Thank you. If you've just joined us, we've been in an insightful discussion with Attorney Henry Haddad on the topic From Non-Immigrant to Permanent Resident, the Adjustment of Status Process. We're now moving into our live Q&A session. This is your opportunity to ask your questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll tackle as many as possible during the session. Right. My story is true, but I don't have many documents as proof to get asylum. Can they still deny me?
The answer is yes. You have to find witnesses. You have to find perhaps magazine articles, something broader that supports what your claim is for asylum. Credibility is one part of the asylum application issue, or all interviews. So if the judge believes you, you still have to prove your case through some third-party means. Usually it's magazine articles or witnesses, even a police report or a hospital record if you're injured. That's very helpful.
Right. I entered more than 1 year ago. With the new rules, is there still a way to get asylum, or can I only get other protection?
Well, nowadays it's difficult to get beyond the 1 year rule unless you had some hospitalizations, medical issues, and so on. So the answer would be generally no. You might be stuck applying for a convention against torture, withholding of removal, subcategories of asylum. But it's very difficult nowadays.
My cousin is a victim of violence with gang threats. I read the news saying this type of asylum is now more hard. Is that true?
Generally, that's correct. Having gang threats or being a victim of a crime in your home country is not enough for asylum. You have to show some kind of government inaction, government corruption, government indifference, that somehow your government did not do anything when you complain to the police about incidents with the gangs and so on. Without government action or inaction, the case is because.
All right. Do I need a human rights report for my case, or narrating my story alone is enough?
Any support you can get is always beneficial. So if you can get human rights reports, State Department reports, any kind of corroborating evidence, not entirely on your case, but about the situation that goes on in your home country, that's always helpful. So the answer is yes. You should always support it.
What happens if I forget something at first and remember it later? Will they think I invented a fake story?
Well, that's going to maybe the government's position, but it's up to you to explain why you didn't include it, or perhaps if you remember it, would recommend you file an amended application and explain why you forgot it. But certainly you have to explain it. If you just give one story on your application and at the interview or in court, you testify to something more or different, that is an issue of credibility. So unless you can explain it, it may be discounted and it'll hurt your case.
How can I show that the government in my country will not protect me, especially after the new BIA decisions?
Well, witnesses, other people from your country, magazine articles, country reports, maybe the State Department has it, maybe human rights reports, international UN reports. You got to dig up something to show that there was government inaction or corruption or action in favor of some other parties or against you, basically.
All right. Now, that was our last question. Attorney Haddad, let's digress a little as we wrap up. How do you see these new H-1B regulations affecting employers' recruitment decisions? And what does this mean for OPT students who are now caught in the middle?
What you're saying is exactly right. It's an area that's just up in the air. It's everyone's guess. It's going to hurt a lot of employers. There is a need for a lot of H-1B workers who come in and do a lot of the work that basically there's a shortage of in the U.S. So we're all trying to get a grapple on what these issues are, what it means. But certainly it hurts. It hurts employers. It hurts employees. And with the OPT and even the time lag, even before this, there are always the issues with the number of applicants and how USCIS is processing it. But now it's become more complicated. So I don't want to stick my neck out and say, yes, there is a way, but it's just big fog right now for all of us.
Yeah. Well, thank you so much, Attorney Haddad, for your time, expertise, and clarity today. Your discussion has provided applicants with the guidance, strategies, and confidence they need to navigate the adjustment of status process successfully. And to all our viewers, thank you for joining this meaningful conversation. We hope today's webinar helps you stay informed, organized, and prepared as you work toward permanent residency. Remember, you can always visit immigrationquestion.com to ask your immigration question free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's webinar or share it with others, the full replay will soon be available on Spotify. Search for Borderless Talk by immigrationquestion.com. Join us again on Wednesday for another live session exploring key immigration topics, including family petitions, humanitarian relief, employment visas, and compliance strategies. Once again, thank you, Attorney Haddad, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay connected.
Thank you for having me on.
Thank you.